Assalamualaikum, sir.
Walaikum Assalam.
How are you, sir?
Fine. I have sent you a recommendation letter.
Sorry, sir. Hello.
I have sent you a recommendation letter that you have requested.
Thank you, sir. Thanks
Yeah.
a lot, sir.
Yeah.
There are two forms. Do you send both?
Yeah, I have sent. I have received one form as an attachment, and I have filled in, and thereafter I have sent it.
Sir, one accompanying letter also needed.
Okay, today we will send. No problem.
Okay, sir. Thank
Yeah.
you, sir.
Have you sent your Trump paper of comparative constitutional law of SAARC nations?
No, sir. Sir, 14 was the last date, maybe 14 February.
Pardon?
Sir, as I know, 14th February was the last, or will be the last date.
No, no, 10th of February. 10th of February is the last date. Haven't you received any email? I have already shared an email.
Oh, actually, sir, I was in another class. Okay, sir. I have to check now.
Yeah, yeah. So today in the morning, I have sent an email.
Okay, sir. So
Yeah.
I will send, sir. Is there any presentation required in comparative custody?
No, presentation is not required.
Okay, sir. Thank you, sir. I will
Yeah,
send before 10th February.
yeah.
So he is Muhammad Amin from International Relation Department.
Okay, Muhammad Amin Amin. Okay, I formally welcome you, brother. Hello, Mr. Muhammad Amin. I think there is a problem in the connection. I'm not able to listen you. Anyway, am I audible to you? You can also write in the chat box. Yeah, thank you. Yeah, please, Mr. Muhammad Amin, share your email ID so that you should get each and everything whatever I am sharing with the rest of the students. Welcome, Mr. Imran. Hello, Jamshed Saab, how are you? Good morning.
Good morning, sir.
Good morning.
Sir, how are you, sir?
I'm fine, brother. How are you?
Yeah, I'm good, sir.
Yeah. Welcome. Today I am scheduled to engage all of you, and that is an area known as the sources of international refugee law. There are sources, or rather, I should put it like this: that in the field of education, or particularly in the field of higher education, we always try to explore, rummage, and try to understand what that exactly has been the origins, genesis, and etiology of our engagement. And international refugee law is not an exception to this particular understanding. Whether it is other disciplines or in the field of science and technology and other important engagements, we always try to understand origins and etiology of our engagement. Therefore, we have already studied the sources of international law, the sources of international human rights law, and the sources of other important branches and disciplines ever since we have started our journey in the field of higher education. And same question remains there, and that we have to answer in the area of international refugee law and how to understand the sources of international refugee law. There are sources which could be divided into formal sources, informal sources, spontaneous sources, and other important sources of international refugee law. Even refugees themselves have also been the sources of international refugee law. It is the fundamental understanding when we are addressing any particular issue or problem in life, then the problem may also present a solution. It may be an inbuilt solution in the problem. Even the refugees have also came out with certain important solutions, as well as on the basis of their lived experiences, on the basis of their endurances, and how they have undertaken different journey and different migrations, remigrations, transmigrations. Therefore, in this particular engagement, I am drawing your attention to understand what exactly are the sources of international refugee law, what has been the evolutionary process. On the basis of these sources, we have received the current regime of refugee protection in the name of international refugee law. And what exactly has been the legal institutional responses whenever community of nation states confronted with the refugee problem. Before I proceed further, it is equally important to understand that there are certain important core texts which I have already submitted to all of you during my orientation submissions. At the same time, it is equally important these sources, I mean the texts and other important readings which we have deliberated during the orientation classes, and subsequently I have already emailed you. They are also the sources of international refugee law. Particularly, this reminds me of one of the most important declaration, that is 1967 Declaration on Territorial Asylum. Another important source of international refugee law is the Charter of League of Nations and the Charter of the United Nations Organization. Then there are certain important other texts, particularly very comprehensive legal framework for protection and assistance of entire humanity, which we find in the 9 core international human rights treaties framework. These international human rights treaty framework, or the treaties which have been encapsulated under this umbrella framework in the field of international human rights law, that is also the part of the sources of international refugee law. Because there are specific articles which have been enumerated in these 9 core international human rights treaties. In other words, we can put it like this, that international refugee law derives its vibrancy, privacy, validity, legality, life and soul from international law, from international human rights law, from international humanitarian law, because there are some specific important articles which are exclusively addressing under international humanitarian law refugee problems. Another important branch of international law that has also emerged as an independent branch of study, that is international maritime law. Then there are certain important international organizations and their statutes. These international organizations presents their framework texts where the problem of refugees to a significant extent have also been addressed. International Organization for Migration, IOM, International Refugee Organization, IRO, then the Nansen Passport of 1922, particularly that was adopted under the auspices of the League of Nations. Then we are also having the statute of the United Nations High Commissioner for Refugees of 1950. We are also having certain important resolutions of the UNHCR Executive Committee resolutions, which are popularly known as EXCON conclusions. They are also the part of international refugee law. Then there is another important, apart from international human rights law framework, the most conspicuous and visible text that comes to my mind is the Universal Declaration of Human Rights. And we should not forget, my dear friends, the magnum opus that has been presented on the protection of refugees, and that has been presented by the ICRC, International Committee of Red Cross. So that is also one of the most important understanding. And that also, constitutes one of the most important sources of international refugee law. This is something which is available in a formal sense at international level. But we cannot ignore the regional arrangements and regional instruments which have been designed over the years on the protection of refugees in a regional context. They also influenced even the lawmaking for the protection of refugees at international level, because contextualized protection of refugees with different kind of criteria and grounds is equally important, and that also influenced the codification of international protection regime. And that is also one of the most important sources of international refugee law. We should also be equally careful of one particular fact, that when we are, rummaging the sources of international refugee law, we should not forget national legislations. National legislations are equally important because there are many nation states, there are many constitutions of different geopolitical entities where from the national legislations have been emanated, enacted, and adopted by national governments. They are also the part of sources of international refugee law. We should also be mindful of the fact that there are, other important sources, and that is the work of International Law Commission, particularly the preparatory texts of different, reports, as well as the works of International Law Commission that has came out. If you take into account, though there are other important, there may be some important, points which I might have, omitted. And at last, we should not forget that there are certain important, specific, fundamental principles which have also come to be recognized as one of the sources of international refugee law, like Article 44 of Geneva Conventions, non-refoulement as a part of, customary international law, and some other important features of the customary international law. Additional protocols to 4 Geneva Conventions of 1949. And the national, constitutions, juristic writings, and refugee voices. I consider them as one of the sources of international refugee law. In this engagement, my dear friends, we are going to understand these sources of international refugee law. We have to further understand the global standards of human rights, which are silently operating, at the same time silently evolving, even outside the 9 core international human rights treaty obligations, which we have studied to a very great extent in our previous semester. We have to understand the coterminous relationships, or let me put it like this, the linkages between international refugee law, international human rights law, international humanitarian law, comparative international law, or constitutional, or rather I should say international constitutional law, international environmental law, and other important emerging branches of international law. We have to understand these linkages. We have to find out the sources of international refugee law outside the purview of international law. And we are supposed to understand the entire evolutionary history of international refugee law, because that also gives us, and bound to give us, some kind of an idea about the genesis and origins of international refugee law. To what extent UNHCR statute should be regarded as one of the most important sources of international refugee law. It would also be, appreciated from the point of view of functionality and functionalism, how UNHCR has been functioning and what exactly has been or is the core function of international arrangement. I mean, the international organization like UNHCR, that is the nodal organization exclusively mandated to address the refugee concerns and refugee problems. Then we have to understand the qualified representative of international public order, and that is the United Nations organization, what has been the functioning of the United Nations organization and how it has been addressing the problems of refugees. Another important dimensions could be, and that should also be taken when we are deliberating the sources of international refugee regime, then we should not forget the age of restrictionism and what kind of derogations of rights, restrictions of rights, curtailment of rights, infringement of rights have been taking place, and to what extent this idea of restrictionism has influenced the making of or evolving the sources of international refugee law. What restrictions does the non-political character of the UNHCR realistically impose on its operations? That is one of the most important and tricky questions. How do we assess, my dear friends, the difference or the different perspectives of different, high commissioners exclusively appointed and mandated to look after as a part of what we call of these, international organizations, particularly the UNHCR, how they have influenced the refugee protection regime, particularly Sadako Ogata, a Japanese lady who headed once UNHCR, then the late professor who has immensely contributed, particularly in developing and making refugee protection legislation, laws, norms, and fundamental principles in the Africa continent. I'm talking of a lady professor who has started the entire journey of the refugee protection in Africa continent, Harold Bond. And she has also been responsible for establishing one of the most important, department for studying the protection of refugees, and that too in the Oxford University, who recently, in 2019, I think in the month of July, she died. Then we have to understand how bipolarism has led to increased interventionism by United Nations agencies, and how does this kind of idea of interventionism has affected the neutrality as well as what mechanism for accountability should be there, and to what extent the nation states have received it. Then we have to undertake to understand the sources of international refugee law in a sense or in the context of UNHCR's emphasis on refugee camps. To what extent these refugee camps have been a successful model for addressing the problems of refugees, or as some kind of springboard for the full-fledged integration, resettlement, as well as repatriation of refugees that has to be taken into consideration. If the refugee camps model has not been successful, then to what extent the international community has been able to find the alternatives to this particular model, and to what extent this particular model has influenced the entire categorizations of sources of international refugee law that we have to undertake. There are some important questions as well. Who are the major actors? Who are the major agencies? Particularly those who have been entrusted with the responsibility of addressing displaced population, governments, intergovernmental organizations, non-governmental organizations, and to what extent the focus of these agencies has been on UNHCR. Then we have to undertake the entire mandate and we have to evaluate it, because that is the most important, conspicuous and United Nations recognized organizations which is functioning as a subsidiary organizations of the United Nations organization. then there are certain important, my dear, phases, which also established a certain important evolution of the refugee protection that has also been recognized as a subsequent stage as one of the sources of international refugee law. That is, if you take into account the entire journey that has started from 1922 and goes up to 1933, and we have also in the very first week we have also deliberated at length, because I have already made a presentation what we have started, which is popularly known as the Treaty of Westphalia of 1648, that should also be taken into consideration. Then, if you take into account how the refugee protection regime has developed after this particular phase, that is a phase that reminds us from 1922 and goes up to 1933. Then there is another important phase of the evolution of international refugee law, that starts from 1933 and goes up to 1942. Then we are also having how the other important subsequent phases, particularly the refugee protection phase, that has strengthened the idea of refugee protection, which we find, and it starts from 1943 and goes up to 1946. And in this particular phase, what we have witnessed is some kind of a facilitation of the work of the allied armies in the conquest of what we call of Europe. Then there is another important dimension, and under this particular dimension, what we have witnessed a kind of a lull period, some kind of refugee protection dormancy we find in this particular period, because in this particular period we do not find any kind of a considerable significant development of the refugee protection, and that is immediately after the Second World War, that starts from 1946 and goes up to the full-fledged conclusion of a refugee protection convention, and that was exclusively devoted to the European diaspora, and that starts from or rather I should say it is up to 1951, which is exclusively addressing the refugee protection regime in the area of geographically speaking, and that is a part of what we call Europe. Then there is another important phase after that starts and make a presentation of a different transformation of the world diplomatic and political canvas. And that is known as the period of Cold War. During Cold War, the biggest casualty has been the refugee protection exercises. Because if you see the present regime, then the present refugee protection regime has established by the creation of United Nations High Commissioner for Refugees of 1950, and with the adoption of the 1951 convention. The present regime premised on the attribution of refugee status by states. And they have been what we call entrusted with the responsibility of implementing their obligations under 1951 convention relating to the status of refugees, and that too with the help of United Nations High Commissioner for Refugees. Today, international refugee law applies very differently in countries of the global north, which have the means to provide for refined administrative processes for refugee determination. Social and labor insertion for refugees and migration control mechanisms. In countries, so far the global south, nation states are concerned, or the countries in global south, where very often refugees come through the borders unchecked, And the UNHCR and other aid agencies are the only institutions able to provide any kind of a support for refugees. Refugees in global north are today better protected by the international human rights law than by international refugee law in terms of refoulement, detention, education, and a range of rights is also provided. Because this kind of points has also been pointed out by some of the important governments, particularly when there has been the swapping of refugees between Malaysia and Australia. Then the government of Australia was worried that why should we go for any kind of a swapping of refugees? And that too with the government of Malaysia. Because government of Malaysia is not, even today, it is not what you call able to provide the international what you call protection mechanism in terms of quality of life, in terms of quality of education and higher education, and the range of rights that has been promised in the schematization of 1951 convention. Whereas in Australia, refugees are enjoying better living conditions, better standards of life. So therefore, these kinds of arguments have always been there. Because it is also axiomatic from the fact that whenever there have been any kind of a refugee exodus from the Afro-Asian nation states, they always moved towards European nation states or the global north nation states. It is altogether a different story that despite all their efforts, all efforts of the refugees, majority of them are not successful in reaching to the European shores. And almost 85% of the total refugee population, as I have already submitted before you on some other occasions, they are being presently hosted by the global south nation states. So every refugee is not a lucky one or the lucky refugee to reach downtown Europe. So they have not been successful. But if you see the quality of rights, whatever the rights have been envisioned in the European constitutions, European national constitutions, and regional instruments, particularly the 1951 convention prior to 1967, when it was not the international instrument, it remained up to 1967 a regional instrument, because in 1967 an additional protocol was adopted that ultimately made it universal, international, or rather global. So if you take into account the quality of rights which are available to refugees, and refugees, whenever they move, they also move in search of peace, education, health, and better living conditions. Therefore, refugees in the global north are today better protected by the international human rights law, better protected with the mandate of international law, with all its manifestations, which are in the name of independent branches. Then human rights treaty bodies, especially if you take into account an example of International Convention or United Nations Convention Against Torture of 1984, that committee of CAT devote a large part of their jurisprudence to cases relating to the rights of foreigners, the rights of what you call of aliens, including the rights of refugees. And the European Court of Human Rights has also developed a very, very important and sophisticated case law, and that is exclusively devoted to the protection of refugees. So that is the beauty of jurisprudence that has been over the years produced in these judicial tribunals of the global north nation states. If you take into account the definition, though the definition would subsequently be deliberated, But if you try to understand what exactly is the nature of the definition of refugees, then by definition, this is my prima facie understanding, my dear friends. The definition by very nature is universal, impartial, individual, indivisible, inalienable, and global in character. Only one element is missing in this definition, my dear friends, and that is collectivism, communitarianism. Otherwise, this definition provides a universal application. Element of universality on the basis of individualism has been the hallmark of this particular definition that has been provided under 1951 Convention relating to the status of refugees with its additional protocol of 1967. Now we have to understand both the instruments together. By virtue of the universal scope of this particular definition as well as of rights, the whole range of internationally recognized human rights standards and principles as contained in the core international human rights treaties also covers and protects older persons, including refugees. UN Covenant on Economic, Social and Cultural Rights and on Civil and Political Rights, my dear friend. These two important covenants of 1966 also include highly relevant provisions for the protection of rights of older people who also constitute a very, very important category in refugee exodus. Particularly, suppose I can name those very rights. Right to health. Right to an adequate standard of living. Right to freedom from torture, and right to have legal capacity, as well as the equality before the law. These are very, very essential and important rights which must be made available to refugee older persons, refugee children, refugee women, and entire what you call even refugee LGBTs and QIs. There are some other important instruments as well. For example, UN Convention on the Elimination of All Forms of Discrimination Against Women, CEDAW. UN Convention on the Elimination of All Forms of Racial Discrimination, that is CERD. They also contain a considerable and significant provisions which are applicable to refugee categorizations and refugee categories. And they got a very, very relevant scope. We should not forget International Convention, my dear friend, on the protection of the rights of migrant workers and members of their families. Because if you take into account Article 7, that includes age. That is equally important for the senior what we call refugees or the senior citizens of a geopolitical entity who find themselves in a state of migration, in a state of relocation. And that is the, if you take into account this particular, convention, International Convention on the Rights of, migrant workers, that includes their members, or I mean the members of their families, that you will find under Article 7 that also includes a list of prohibited grounds for discrimination. And one of the most important grounds happens to be the age. That is why that constitutes a very, very important dimension. Even Office of the United Nations High Commissioner for Human Rights developed a background paper, my dear friends, and that background paper is popularly known as the Human Rights of Older Persons, International Principles and Standards. And This particular, paper has been adopted in the year 2010 by the expert group. So there are, fundamental principles. Even ordinary declarations, what we call the soft international law declarations, fundamental, paragraphs which have been, incorporated. Suppose in the field of, international environmental law, the Stockholm Declaration of 1972, Rio de Janeiro, Declaration of 1992, an entire what you call, journey of COPs. They also constitute one of the most important, guidance, and that should also be to a very great extent has been treated and regarded as one of the sources of international refugee law. So if you take into account cumulatively these aspects, then it is going to be our, well considered understanding. You may agree, you may not agree with me, that there happens to be an evolution, there is an evolving element, and that evolving element is the element of complementarity. And this element of complementarity should be taken as an evolutionary process of the sources of international refugee law. Because we have to find out linkages. We have to develop coterminous relationships. We have to what we call, develop the idea of cross fertilizations of international refugee law with other, disciplines of human engagement, research engagement, academic engagement, understanding engagement, higher education engagements. And this is how we should, cumulatively understand the idea of international refugee law. We should not simply take some kind of a solace that we are having only two instruments. United Nations, 1951 UN Convention relating to the status of refugees and its additional protocol of 1967. No. International refugee law, my dear friends, in terms of, sources, in terms of applicability, in terms of understanding, is not limited, is not confined to these, two important instruments. Yes, of course, I understand that this is the subject matter of international refugee law, but we cannot underestimate the incidental, ancillary, and collateral instruments. And that, provides an element of, complementarity, compatibility, transportability, applicability. So we should not, forget these other important elements. There have been scholars, including, student scholars, who have posed, and generally they pose this question in the classes. I had a chance to visit some of the, best law schools in the global north. Once I had an informal interaction with some of the students in the Oxford University on the sidelines of an international, conference on refugees. And these students, a group of 3 or 4 students was hailing from the Eastern Europe. And they simply put this question, including if I quote my experience of the South Asian universities, classrooms, then the initial batches, batches of 2014, 15, 13, they also posed these kinds of, questions. If the problem of a particular refugee group or refugee individual or a refugee collective cannot be solved by applying 1951 Convention relating to the status of refugees, with its additional protocol of 1967, then how to solve refugee problem? This has been the nature of question. There has been some other, direct questions. Why there are so many refugees and we can't solve their problems? Something like, these kinds of questions have also been there, and there has not been any kind of a difference whether the questions are coming from the global south or the global northeast. There have been another form of question. One student very agitatingly put a question, and he was from the Faculty of International Relations of the South Asian University. And right now he is working with the refugees, Rohingya refugees in Cox's Bazar, the border, what you call, city that, borders with that of, Myanmar. 3 or 4 days back, I have received his email. He wanted, some literature. He was of the view that the 1951 convention relating to the status of refugees has already lost its utility. It should be scrapped. So all kinds of questions keep coming. Then I generally take these questions. There are many other questions as well. I'm not able to recall all the questions, but these kinds of questions I have been facing. There is no negativity in these questions. There is always a considerable amount of positivity is present in these questions. It means the student community is agitating. They are agitating only because they have studied these conventions. That is why they are asking questions. And this is my firm belief that the students, if they are asking questions, it means they have gone through the literature. That is why they are able to ask questions, because the questions cannot be put in vacuum. You are having a significant and considerable information about different dynamics and dialectics of international refugee law. That is why these kinds of questions students are asking. Then here comes the role of other important sources of international refugee law. Generally, when we try to understand what is refugee law, we confine ourselves exclusively to these two important instruments. And we generally do not count the rest of the instruments, because international refugee law is an interdisciplinary subject. This is my understanding. Because there is a range of factors which are responsible for the human displacement. There are anthropological factors, there are scientific factors, there are technological factors, there are neurological factors, and there is also X factor, which we have to decipher in a given time. If you take into account the entire congery or entire congeries of these factors, you will find that there are factors which have not been reduced into black and white. There are gray areas where no scholarship is available, where the writings happens to be in their infancy. So we cannot take into account all the factors in a single go. And therefore, if you decipher each and every convention, each and every human rights treaty, you will find a different kind of a dimension is available. If we are, suppose, going to study United Nations Convention on Rights of Child of 1989, then there are refugee children. There is a convention on migrants worker. Then there are migrants. There are refugees. And my dear friends, we should not forget. If a person started his journey as a migrant on valid what we call documents, identity documents, travel documents, and there is every possibility he started his journey as an immigrant or as a migrant with lawful papers. But there is every possibility when he lands at the destination, he may be a refugee. So number of situations. There is a separate category for such people. A person who started from Dhaka to visit United States of America as an ordinary citizen of the state of Republic of Bangladesh, but he lands as a refugee and demands a refugee status or seeks some kind of asylum, and that is warranted because of change of circumstances in the country of origin, and that is Bangladesh. There have been instances like this. So in such kind of situations, we should not forget international immigration law or immigration law. That is one of the sources of international refugee law. And immigration legislations have been there of a national character. So national legislations, to a great extent, have also contributed to evolve and to present that they should also be regarded as one of the sources of international refugee law. Then in such a scenario, there is another important dimension, and that is what exactly are the rights of refugees? What are the rights of refugees? That is one question. And when we are talking of rights of refugees, though formal incorporation of entire range of rights have been there in 1951 convention relating to the status of refugees, a whole range of rights. At the same time, we should not forget national constitutions of South Asia and the national constitutions beyond South Asia. Because we should be clear-headed when we are talking of the rights of refugees, then we should not forget, my dear friends, then rights of refugees is the subject matter of international law. This should not be forgotten. The rights of refugees derive their genesis, origins from a trinity of sources of international law. From a range of treaties. Formally speaking, when we are using the trinity of international law, the trinity of sources of international law, we have been confining ourselves to international human rights law, international humanitarian law, international refugee law. But we should not forget the rest of the branches of international law, which have over the years have also established themselves as an independent disciplinary engagement, like international maritime law, intellectual property rights law. Even intellectual property rights law has also made adequate what we call provisions for refugee migrations and refugees. Because when we are discussing the right to livelihood and right to dignity, then we should not forget, my dear friends, intellectual property rights law. Because the refugees have also contributed in enriching intellectual property rights law. There are refugees who have immensely contributed in the development of patents, copyrights, and other important industrial designs. We should not, and they have also contributed in the technological development and technological advancement. So they also got a right to patent, right to copyright. So whatever the international, conventions which have been, adopted under the, auspices of WIPO, World Intellectual Property Organizations, that is, equally available to refugees as well. So right to have livelihood has got different, dimensions, different, semantics. So that is also touching intellectual property rights. Same is the, principle we can also stretch is to encapsulate international trade law or in international investment law. So refugees have also been, at the forefront, and they have, contributed in nation building, in project buildings, in what you call community building, or creating a new important elements in the social integration in the host, communities and destination countries. So that is why. And these are another important, colors of their sources. So therefore, we should not, underestimate their contributions, because it has always been the practice of various, geopolitical entities that they have always regarded refugees as some kind of a national threat, a national security threat, as a symbol of some kind of a terror, what you call, threat, some kind of a financial, social, cultural liability, instead of making them an asset, a national, asset, and utilizing their services in national building projects. That has never been the cup of tea of many national governments in global south as well as in global north. Therefore, there are, certain important general principles of international law, international treaties, customs, juristic writings. They also form the sources or the main sources of international refugee law. Though it may be technically correct, but it is beyond the rubrics how to do justice. Because there have been real disagreements, my dear friends, regarding as to how rules are identified and founded upon custom or general principles of international law, and subsequently recognized as human rights norms, which are generally employed to facilitate the integration, resettlement, and repatriation of refugees in a geopolitical entity. But there is a need to have, when we are dealing with the question of refugees, then in my individual capacity as a student of international refugee law, my dear friends, it is important to have a liberal understanding of refugee concerns. Because sense of accommodation, a sense of temporary protection, though we are going to have a separate week on temporary protection, because temporary protection is a very vast area of engagement, intellectual engagement. And it's a multi-dimensional engagement. So I would be discussing in that very week what exactly are the contours of temporary protection and to what extent it may be added and enrich the existing what you call category of durable solutions. But when we are talking of refugee and refugee protection and reception of refugees, then a liberal understanding is the prerequisite. You may agree, you may not agree, and your disagreements are very respectful for me, and very respectfully I am going to accommodate your disagreements on this particular point. Because our thresholds of nationality, race, caste, creed, religion, sexual orientation, political opinion, membership of a particular social group, social genesis, regional affiliations, human rights, dignity, rule of law, democracy, cosmopolitanism, diversity, multiculturalism, all are different. My level of understanding of diversity is different from your level of understanding. You may have different intersectionalities of understanding of these important elements which I have enumerated a moment ago. Therefore, it's a multi-layered understanding. And you have every right to have your individualized understanding of refugee problems and refugee concerns. But what is important exclusively in my capacity as an individual, as a student of international refugee law, and that too at the higher education level, then I see there has to be a need of a liberal understanding, a liberal critical appreciation should be there of the refugee rights. A liberal interpretation should also be there as a prerequisite, particularly of the sources of both custom and journal principles, exclusively premised on a consent-based, modern, dynamic view of international law. That kind of an interpretation must be there when we are talking of international refugee law and international refugee law sources, as well as how to address the question of refugees. There are, very strictly speaking, there are significant sources of international law which have been identified under Article 38 of the Statutes of the International Court of Justice. If you count their numbers, they are 4, my dear friends, and this is something I'm not saying for the first time. Even you have already studied as a student of customary international law. You already studied as a student of international law when you were deliberating what exactly are the 4 formal sources of international law. International conventions establish written rules that are binding on states and ultimately, signed and ratified the, conventions. Treaties are contractual in nature between and among states and governed by international law. That has been the mandate of Article, 38, and this is something you already studied as a student of international law. Then the international custom that, that establishes unwritten rules and that are binding all states based on general practices or general practice. At the same time, their binding power is based on applied, consent, and that is also, evidenced by certain important, elements like uniform state practice, as well as what we call there has to be a belief that such kind of a practice is a legal obligation, which is popularly known as the opinio juris. So all these elements you have studied, my dear friends, in your international law engagements and international human rights law engagement. And again, at the same time, when we were discussing the week 2 of international human rights law, we have also deliberated these aspects. And of course, I should not forget the general principles of law recognized by civilized what we call nation states, and that includes, my dear friends, the idea of just cogence or the preemptory norms of international law, wherefrom no derogation has been permitted, no derogation is allowed. At the same time, we should not forget the United Nations Charter, and the United Nations Charter prohibits the use of force except in self-defense, and that is also not a novel what we call idea. But in case of refugees, and to understand the refugee sources, these fundamental principles should not be forgotten. So meaning thereby When I have said a moment ago that international refugee law is an interdisciplinary subject, then my dear friends, what I have been intending to say, what kind of a point I have been deriving home, my only submission is that we should not forget the element of complementarity. Even within the national jurisdictions, if a nation state is not a party to 1951 convention, if a geopolitical entity is reluctant, despite being a party even to 1951 convention relating to the status of refugees, then we are having, and in the absence of a national legislation, then definitely we are having a supreme legislation, a calcinite legislation, which is known as the grand norm of the land, which is known as the constitution. Then constitution is the best what we call remedial measure where under the refugees have been protected, despite the fact word refugee has not been implicitly or explicitly used. But there are attributions when there is a question of the rights of the citizens and rights of people, when there is a question of diversity, when there is a question of multiculturalism, when there is a question of cosmopolitanism, then definitely the rights of refugees and their protection has been provided under the constitutions as well as, and that comes out of the judicial what we call decision, the judicial adjudication and the teachings and other important publications of scholars. Then this is how we should protect refugees in different what we call geopolitical entities. Then if you take and go what we call further in the area of international human rights law, from international law, then I have provided you enough what you call fodder and given you certain important examples of different conventions and treaties. But as a whole, if you take into account international human rights law, then international human rights law comprises a set of rules established by treaty or custom, whereunder we find a very, very high adumbration of obligations and duties of states to respect, protect, and fulfill human rights. International human rights law enables individuals, my dear friends, and groups to claim certain behaviors and benefits from their respective governments, respective states. International human rights law contains a number of provisions relevant to humanitarian assistance and humanitarian assistance that assist in the enjoyment and accessibility of the right to life, right to food and water, right to establish medications, Medicare, healthcare, and sanitation, rights to adequate clothing and other necessities of life, which are essential to sustain a dignified existence, and the right to equality and non-discrimination. This should not be taken as a platitude. This should not be taken as some kind of a trite repetition. No. It should be taken as some kind of a sensitization of a very special group called refugees. Because when we are talking of refugees, then everything becomes subservient. If you take into account the intersectionalities of refugees, you will find there is a religion, there is a race, there is a caste, there is a creed, there is an opinion, cultural opinion, political opinion, anthropological opinion, philosophical opinion, all kinds of opinions you will find there is what we call, gender. There is a, sexual orientation. There is some other, form of, categorization. But cumulatively, when somebody becomes a refugee, then nobody wants to be a refugee. And we are dealing with refugees. So we should forget their intersectionalities. If you take, for a better understanding of my line of argument, if I say students of South Asia, then intersectionality would be South Asian students in the Faculty of Legal Studies, South Asian students in the Faculty of Social Sciences, the South Asian students in the Faculty of Biotechnology or Development Economics or International Relations. Then there is a further what we call, intersectionality, a multi-layered form. The South Asian student community in the Faculty of Legal Studies, then they are hailing from different countries. They are also hailing and professing different kind of, religions. And sometimes there are, minorities, like, Hindus from Pakistan, they are also having a religion, but they are a minority. So these intersectionalities of identities should not be the bone of contention. And unfortunately, my dear friends, these intersectionalities of identities have become the bone of contention before the national government. And they are not discussing refugees. They are discussing primarily their religions. So religion has become a bone of contention. And that is the, negation. And that is the biggest, what we call, disservice to the cause of refugee protection. We generally say Rohingya refugees, but there are, some scholars who are using the word Rohingya Muslim refugees. This should not have been the case. We have not been dealing with immediately after the Second World War as an aftermath. There has been a lot of what we call, intra-European migration of people or refugees. They haven't been what we call, addressed as Christian, refugees. But in Afro-Asian nation states, religion has become a very, very important what we call, testing ground to assist or to extend any kind of a humanitarian assistance to refugees. That is a violation of the entire, highly sensitized instrument, which is known as the 1951 Convention relating to the status of refugees. And that is why if you evaluate why religion has become the part or one of the most important grounds that has been encapsulated in the definition clause of 1951 Convention relating to the status of refugees, these were the apprehensions of the world community. It has been the collective wisdom of the global community or international, wisdom, whether you call it a Geneva-based wisdom or what you call, Marrakesh-based wisdom, where recently we have adopted global compacts on refugees and on migrants in 2018. Whether it is the humanitarian wisdom based at Geneva or whether it is going to be a political wisdom based at New York, when for the first time under Obama administration we have adopted and came out the political realization in the name of or in the form of 2016 New York Declaration on Refugees and Migrants. So we have to decipher. We should be very sensitive why we are not adhering to the very fundamental principles. And unfortunately, my dear friends, South Asia is a fit case to evaluate all these dimensions. I don't know why we are not what we call formalizing our engagement with refugees. In an informal sense, we have been assisting refugees. We are having the two important aspects. of dealing with refugees. Internal treatment, I mean the national treatment, and the externally what we call treatment or transnational treatment. If you take into account the transnational treatment of refugees of India, Pakistan, Afghanistan, Bangladesh, and Sri Lanka, including what we call Nepal, you will find some kind of a dichotomy. And this dichotomy should not be there, because there has to be an element of uniformity, and uniformity establishes humanitarian character of our sensitivity. And very sensitive measures are a prerequisite to deal with the problem of refugees in South Asia. Because the sufferings, pains do not have any kind of a religion. Religion can never be the bone of contention to determine the pain of an individual. So therefore, it is in the fitness of our understanding, a religion neutrality should be there when we are going to determine refugee status or going to dispose of refugee applications or asylum seekers application who have been knocking our doors and submitted their applications for refugee status. Take the example of Afghanistan. Afghanistan is a country who is a refugee producing country. Most of the refugees are being produced by Afghanistan, but at the same time, Afghanistan is also hosting refugees from Central Asia. And there is a difference how it has been hosting refugees and how it has been what we call exporting refugees. We can also take the example of Sri Lanka in South Asia. How the refugees are being hosted. How Somalis, Syrians, and Indian what you call refugees are being hosted in Sri Lanka, and how the Sri Lankans are being hosted in some of the countries of the Southeast Asia. We are also having refugees in Nepal. What kind of a mechanism has been evolved by the government of Nepal, and what are the important provisions? Because Nepal is not a party to 1951. In entire South Asia, we have only one country, and that is Afghanistan, who has become a party to 1951 convention relating to the status of people. But rest of the countries are not the party. And since 1995, Pakistan, India, and Bangladesh happens to be on the executive committee of the UNHCR, and they have been assisting and coordinating their refugee protection activities with that of UNHCR on ad hoc basis, on policy basis, on informal basis, on governmental basis. But there has not been any kind of a formalization or institutionalization of their engagement. And that is the most worrying point. An institutionalized approach is the requirement of the present circumstances. And this, requirement, if we are, espousing for the cause of international leadership, if we are, demanding a permanent seat in the Security Council, if you are taking and spearheading the cause of further democratization of the United Nations organization, if we are espousing the cause that the United Nations organizations must reflect upon the current political realities in Global South by reforming, rearranging, and rejigging the existing political structures of United Nations organizations, which are representative of 1945 political realities. Then in such a scenario, there would be an international assessment regarding our international obligations and commitments, and particularly in crisis of international character, particularly the humanitarian crisis. That is why it becomes very, very relevant to understand our geopolitical setting and our what we call, institutionalized approach in the world refugee map. Because if you take into account the entire refugee population, then we require a new country exclusively meant for refugees. We require a new planet for refugees. There is so much highly truncated and truncated refugee migration that is taking place. There is some kind of intense, extensive crisscrossing of humanity. So in this particular background, we are supposed to understand, my dear friends, the entire refugee problem and its sources. Because when we are talking of the displaced persons, then we cannot forget another important humanity of the displaced people, which is popularly known as internally displaced persons. And when we are talking of the internally displaced persons, for all practical reasons, their requirements are same. Their requirements are similar to the requirements of the refugees. Both the groups are having identical requirements. The only difference or the point of difference is that internally displaced persons do not cross international borders. Rather, they move from one place to another place. They relocate from one place to another place within the national boundaries. But the movement, displacement, relocation, migration, remigration, transmigration, these are the features of their mobility. So they also got the same kind of problems. In the name of development, in the name of what we call some other important changes like climate change, they are bound to move. They are compelled to move. They are forced to move from their natural habitation to their own other important kind of habitations. So they are also benefiting. So far internally displaced people are concerned, they are also benefiting, my dear friends, from international human rights law, from international humanitarian law, and from the guarantees which have been promised and envisioned in the structural justice that has been incorporated in 1951 convention relating to the status of refugees, and particularly so far the protection of internally displaced people are concerned, then we should not forget armed conflict and the guiding principles on internal displacement, which have been issued by the United Nations organizations in 1998 from human rights standards and developed to provide protection and assistance to this particular category of humanity. So we should not forget. And it becomes very, very important. If you take into account further, international humanitarian law as a source of international refugee law, then this particular discipline, IHL as a discipline of international law, that has been exclusively guided, propelled, and is inspired by considerations of humanity, my dear friends, and the mitigation of human suffering has always been the primary goal of international humanitarian law, then it is consisting of certain important set of rules established by treaty or custom, as well as other important notions of a humanitarian character, which also comes from international human rights law, which seeks to protect persons and property, objects, and which are generally affected by armed conflict, and limits the rights of parties to a conflict, how to use, what kind of a use of force should be there, what kind of a methodology during the combat should be employed, and the method and means of warfare, and their important, I mean, their predilections and choices. That is also one of the most important mandate of international humanitarian law, and that therefrom we try to derive, because whenever any armed conflicts happens, my dear friends, that we also witness the lot of what we call human displacement, and it becomes more important if we take into account the history of armed conflict. We are having the two important historical accounts. Number one is the World War First, and the second one is the World War Second. Then there has been some other important, regional wars, like Vietnam War, like Korean War, like Gulf War, like other important wars, where the fate has been the same, and that has been the human suffering. But why I am pointing out these two important wars, and specifically the Second World War? Because there has been a canvas of carpet bombing during the Second World War. How Britain has resorted the carpet bombing of certain important German cities. No important, and particularly even the civilian populations were not spared. Whether it is Dresden, whether it is Berlin, whether it is Bonn, and other important industrialized cities, and they wanted to what we call they wanted to stop the manufacturing of the war machines and the war planes, and that is why some of the important industrial cities during the Second World War were also bombarded by the Air Force of Great Britain. But the biggest casualty has been the civilians, because it has been thought cumulatively and collectively by President Roosevelt and Winston Churchill that the morale of the general masses should also be contained. They should be demoralized. So therefore, the civilian population has deliberately been chosen by all the stakeholders during the Second World War as the targets. The targeted killings have been there, and that too in the name of war. So it becomes very, very important, and that is why we have received these 4 Geneva Conventions of 1949 with their additional protocols. It has been identified what should be spared and what should be targeted, what should not be targeted. And one of the most important category happens to be a category of civilians and their necessities, including wells, including the water bodies and other important, items which are essential for the human sustainability. So therefore, IHL has informed the development of humanitarian, fundamental principles in the provisions of humanitarian or international humanitarian assistance, particularly the provisions pertinent to the protection of civilians and delivery of humanitarian assistance. Then this becomes the basic and the fundamental, premise in understanding how to protect civilians and humanity during the armed conflict, because most affected people have always been there, and these were the two important categories, women and children, and they have been categorized as war refugees. If you take international refugee law per se or as sources of itself, Then international refugee law, my dear friends, encompasses a set of rules established by treaty or custom, again, with the aim of providing protection and assistance to individuals who have crossed international borders and are at risk or victim of persecution in their country of origin. The word persecution becomes very, very important, but unfortunately, or unfortunately, both, I mean, both adverbs, what you call, should be used. Unfortunately, I am using that we are not able to determine the province of persecution. And fortunately, I am saying it is good that we do not have any province of persecution. Though it remains volatile, but at the same time, this volatility provides us an opportunity to incorporate and to stretch its scope, to encapsulate and to incorporate new situations of persecution. That is the beautiful, argument. Could be a beautiful argument in the service of humanity. You may also ponder over, because if you take into account refugee definition, then you will find that it has enumerated 5 important dimensions of persecution, which I would be taking up in the next engagement in the week, what you call third or fourth, that has been devoted to definition aspect. Grounds of persecutions have been enumerated, but what exactly is the persecution, this has not been dealt with. Though the grounds of persecutions are axiomatic from the definition, but there are other important elements which have not been mentioned, and they are equally applicable, and people have been fleeing persecution on those very grounds which have not been mentioned in 1951 convention. Rather, they have been mentioned, my dear friends, in 1969 African Organization of African Unity Convention governing the specific aspects of refugees of 1969. That is a regional arrangement applicable exclusively in Africa. And that has further been appropriated by the AU Council as well, African Union Council, when they have passed a constitutive act in 1981, if I'm not wrong. So, if you take into account all these aspects, you will find that the legislative wisdom of the European minds, when they have adopted in 1951 a convention devoted exclusively to European intra-migration of refugees, which is today known as 1951 Convention relating to the status of refugees, that was made universal by adopting in 1967 an additional protocol. We should appreciate their wisdom. They did not bother about what could possibly or potential province of persecution. Because if you take into account the definition that has been provided by the African Convention on Refugees, and it has been in the subsequent juristic writings, it has been acknowledged that these two conventions, one is the International Convention which has individualized refugee protection, and the African Convention of Refugees which has collectivized refugee protection. These two conventions should not be perceived at loggerheads with each other. Rather, they should be perceived as a complementarity to each other. Because what remains to be there at the ground is a refugee, whether he is fleeing from the armed conflict or he is fleeing because of the political opinion, because of the sexual orientation, or because of membership of a particular social group, or because of the foreign domination, or because of the massive violations of human rights, or because of some kind of political opinion. But what is important is it is the human suffering. At the ground level, we have been receiving a refugee. And what becomes important? The important element happens to be the human suffering. And what needs to be done? Then the entire categorizations of the idea of or entire trajectory of durable solutions should be invoked to facilitate his resettlement, reception, destination, and a congenial atmosphere. An element of safety should be provided. A very congenial and refugee friendly atmosphere in the country of reception should be, because what happens to be at stake, it is the right to life. But right to life does not, or merely includes the right to physical security. It goes beyond that. A physical sense of security should also be there in his or her mind. That is important. It is so sensitive. In this situation, we have to undertake the idea of what we call of sources of international refugee law as well as, and that is why the element of complementarity, that is why element of compatibility. If refugee cannot be protected, my dear friends, under international law, under international refugee law, under international humanitarian law, under international criminal law, then under constitutional law they should be protected. Under customary international law, or what I call national international law, in other words, or comparative international law, they should be protected. What is important is humanity should never be put at loggerheads with humanity. One should not be allowed at war with himself or herself. That is the negation of international law, international principles of human existence, which have been incorporated under customary international law. Therefore, it becomes necessary to provide all kinds of protections to refugees. Then another important discipline you can further evaluate, and that is the discipline of international criminal law. International criminal law, ICL, it's relatively a new body of law. All of you are well aware. It is started only in the last 25 years or the 22 years. Under international criminal law, we find a prohibition of certain categories of conduct viewed as serious atrocities, my dear friends, particularly the war crimes, if you take into account crimes against humanity, including genocide. Crimes against humanity is also having a very comprehensive and detailed intersectionality and fragmentary nature that should never be forgotten, and it is keep on evolving. And certain fundamental principles of criminal intent and criminal element, which all of us have studied as a part of our national penal laws, as a student of national penal laws, substantive what you call penal laws. International criminal law also seeks to hold accountable individual perpetrators of the criminal conduct and criminal culpability, Here I would not be evaluating what has been the functioning of the International Criminal Court, that is ICC, under the Rome Statute of 1998. The questions of credibility, the question of efficacy, relevance, and how International Criminal Court has also started losing its credibility on some other occasions, definitely we would be appreciating, but not as a part of international refugee law. It would be deliberated under week what we call 11 as one of the most important issues, because week 11 is the collection of international issues which are affecting refugees. And why the major stakeholders and the so-called champions of human rights, including United States of America and some of the European nation states, are not the party to the statutes of the International Criminal Court, the Rome Statute, which is popularly known as. So we have to take into account how war crimes has resulted in the human displacement or forced human displacement, how crimes against humanity has produced another category of refugees, and how international criminal law that has been allowed to function, my dear friends, through international ad hoc tribunals, and what exactly have been the norms which these ad hoc tribunals have produced, and to what extent they have been perceived and incorporated as one of the sources of international refugee law. Not only the ad hoc tribunals, my dear friends, even the mixed tribunals, or we may call them the hybrid tribunals, and how these tribunals and international criminal courts have been functioning in tandem with the national judicial establishment or national courts, and how these courts have further facilitated and enriched the criminal jurisprudence, where refugees have been given a significant and conspicuous treatment with regard to the protection of their rights and other important elements of their existence, sustainable existence of refugees, a humanitarian existence of refugees, a human rights oriented existence of refugees. There are other important dimensions of this interdisciplinary approach in terms of sources, in terms of scheduling the sources and rummaging the sources of international refugee law. Then international disaster response mechanisms are also there. And these mechanisms also constitute a very, very important stage of our academic journey in understanding international disaster response law, which I call generally IDRL. Because there are certain important fundamental principles, certain important rules and regulations, and we should not forget the certain rules and fundamental principles which have also been invoked by the national governments in the wake of the global pandemic. Because the global pandemic has also pandemic to the movement of people. It has also facilitated human migration from one place to another place. And these kinds of migrations have also become the part of the larger social milieu. And therefore, this has also provided us an opportunity to understand further what exactly should be other important arguments as well as other important sources of international refugee law. Suppose take the example of this pandemic. Then in majority of the nation states, certain measures in the name of containing the spread of coronavirus has also been, invoked. Health emergency proclamations have also been issued. Certain fundamental rights for certain, human rights have also been restricted. Some of the rights have been, derogated. So in such kind of, situations, how the, right to movement, right to human mobility has been, curtailed. But another important, dimension that, comes to my mind, that is also natural, what you call, disasters, as well as international disaster response laws. If you take into account IDRL, that has been, received as a new area of what you call of academicians, focus, or the focus of international scholarship, particularly international law scholarship. Expanding, my dear friends, IDRL has also expanded international humanitarian law framework because it covers humanitarian assistance to populations in the context of natural disasters. That has also presented, because when there happens to be any kind of a natural disasters, I'm not going into the causes. It may be climate change, it may be anthropological interventions, it may be industrial, what we call, disasters, because of, some kind of, seismological imbalances, where even the, where some kind of an industrial activity, because of what we call of the science and technology, because of the, explosions, or implosions, rather, I should use the word, not explosion, implosions of the nuclear, bombs, or nuclear, testing. They contain just what we call, contain and conducting these kinds of, implosions under the, earth, or beneath the, earth, where it is going to affect even the movement of the tectonic plates, which result into some kind of, natural disasters at a subsequent stage. And the result is always the human displacement. So in such a scenario, IDRL aims to facilitate humanitarian assistance to persons that do not benefit from the protections of the international humanitarian law. It is relevant only in situations of armed conflict, because we generally invoke IHL in such, situations. But so far, the rules of, IDRL, International Disasters Response Law, rule and regulations, these are not based on a core treaty or the core treaties, but are derived from a broad range of, sources. International Disasters Response Law derive their, authority, legitimacy, as well as applicability from certain important, treaties, specific provisions of the, treaties, including Millennium Development Goals, Sustainable Development Goals, other important what we call, paragraphs and principles, other important, soft laws, or the hard laws like treaties and conventions, resolutions of the United Nations General Assembly, declarations, codes, guidelines, protocols, certain important, diplomatic procedures. System is very complex. When we are basically deriving and evolving this new branch of understanding, then not only it is complex, but at the same time it is, vertically as well as horizontally truncated one, fragmented one. And some common themes ultimately emerged out of it, and that requires some kind of a progressive development. And therefore, we can also plead its, codification in years ahead. So, if you take into account this cumulative impact, in the sense how to enrich refugee protection, then no stream of law, my dear friends, no dimension of law should be left in isolation. Rather, we have to invoke the cumulative impact of each and every kind of a dimension. All dynamics of rules and regulations, which generally facilitate all dimensions which are of humanitarian, human rights, and refugee law and constitutional character should be invoked to facilitate human integration and ensure refugee protection. That should be the what we call understanding when we are deliberating on the aspects of the sources of international refugee law. Otherwise, because it is the sources of international refugee law, we should be cajoled first, and thereafter we should try to understand the implementation, how to ensure the implementation and execution of these fundamental principles. Whenever any legislation, national legislation happens to be there in South Asia, we should ponder over all these sources, because there have been certain important initiatives on the part of some specific individuals in their personal capacity as a member of legislative bodies in South Asia. They made presentations of these private members bill, but these bills are still lying and gathering the dust in the corridors of power. No credible information is there. What happened, what has been the fate of these bills. But there is a need, and we should what we call adopt a policy of engagement. We should become, this is my as an academician, as a student of international refugee law, this is my fundamental understanding that all South Asian nation and states should become the part of 1951 convention. And those fundamental principles which have been incorporated under 1951 convention, one must also be reflected in national legislation. We must have a national legislation, a specific legislation exclusively devoted to the protection of refugees with adequate safeguards on internal security, on national integration, and integrity of personhood. Public policy, all such dimensions would have been there, but I would further deliberate on its contours in the week ahead, because we have exclusively devoted, and what exactly has been the development in evolving a refugee law at regional level in South Asia would also be deliberated in a separate what we call engagement, because adequate material as well as academic wherewithal is available to discuss all these notions. So I will continue, my dear friends. So thank you very much for being with me. Thanks a lot. See you tomorrow.
Thank you, sir.
You're welcome.
Thank you, sir.
And please, before you leave, just a moment, please, just a moment. Let me request. Yeah, please spread this word that students from sociology, international relations, as per the past practice, they are allowed to opt for this particular paper, because I haven't received any official communication from the department, from the faculty assistant, the faculty of legal studies. There has not been any kind of a formal information regarding the choices of students for this particular paper from these departments. So please you submit, Mr. Muhammad Amin and some other fellows have also been there. Please submit your choices to the Faculty of Legal Studies nodal officer, who is known as the faculty assistant, Mr. R.K. Trivedi, and whatever the procedure requires to be fulfilled in this connection. So please complete all the formalities designated and formalized in this regard. So thank you very much.
Thank you.
You're welcome.
Thank you, sir.
Thank you, brother.